Okay, welcome everyone. We will continue in a moment. I was just going to say, when I was a little bit younger, I used to always have people want to show me pictures and tell me about their grandchildren. I always wondered why they thought I was interested. Until now, that today is my youngest granddaughter's birthday, and so I'm telling everybody because I don't care who's interested. It's just the way it is now, so I understand all of that previously. Mr. Balzer, you're standing, so.
Good morning, Mr. Chairman. I wanted to just raise a scheduling issue and ask the Commission's preference. We have a date certain witness today, Mr. George Winnick. He's here. We're prepared to put him up. I think it's important that we get him up and down today because of his scheduling conflicts. So we are prepared to put him up out of order and start him now if that is what the Commission would prefer, or we can finish the previous panel. But I do have some concern about whether the cross of the existing panel will extend to such a point that we might not be able to finish Mr. Winnick today. And I'm sure the Commission will be interested in Mr. Winnick's testimony. I'm sure we'll have questions for him. So that would be our suggestion, if that is okay with the Commission.
If that works with you, that's fine. We'll do it that way. So,
thank you, Mr. Chairman.
Mr. Chairman, one other small housekeeping matter. In introducing Dr. Lynch's testimony yesterday, I failed to move into the record two exhibits to his testimony in dockets 2017. 305 and 2017 207E. Those are the two exhibits there, which are JML 1A and 1B. I would ask to move them into the record.
Okay, we will enter those as exhibits, as Exhibit 105. Okay. Continue on, Mr. Balzer. Make sure you get that microphone on.
Good morning, members of the Commission. On behalf of SCENG, we would call Mr. George Winnick to the stand.
Welcome, Mr. Winnick, and we'll make sure you get your microphone on. And after Ms. Wheat gets you sworn in, we'll be ready to go. There you go. I'll be honest, I almost started off with that on the big screens today.
Oh, yes. Okay. Yes. I do.
Mr. Chairman, to facilitate the examination of Mr. Winnick, we've prepared notebooks for members of the Commission of the exhibits that we intend to introduce. We think that'll speed things along, and if it's okay, we'll hand those up. Mr. Winnick, could you please state your full name?
George?
Mr. Chairman, I need to interject. We'd like a copy of the notebook. These aren't pre-filed exhibits that I know of.
We intend to hand out exhibits as they're introduced to the parties.
Well, given that they've been handed out already, I think we'd take them now.
Yeah, I was going to say, I'll look on with you, and you can use this one.
Do we have an extra one, Julian? Okay.
Yeah, that's what I can share with Mr. Butler right here. We can give that.
Mr. Winnick, can you tell the commission what your occupation is?
Yeah, so my full name is George Darrell Winnick. My occupation is attorney. I've practiced law since 1975.
Make sure you stay right in front of that microphone because it won't pick you up on live stream.
Yes, sir.
Thank you.
Where do you currently practice law?
I'm a partner with the law firm of Smith, Curry and Hancock in Atlanta. Smith, Curry and Hancock is what I guess they still call a boutique law firm. All of our lawyers practice construction law. We have a national footprint, but we're based in Atlanta. We started in Atlanta. And we're probably one of two firms in the country that focus exclusively on construction law and have that national footprint.
And within the rubric of construction law, do you have an area of focus of your practice?
Well, I've done a lot of things over the, I guess it's 43 years now. So I don't slight those things, and I still handle a variety of cases. I've had airports, dams, highways. But in the last, I would say, 30 years, the majority of my work has been power work. Power plants that are fired by coal, natural gas, some waste to energy plants. I've done some nuclear turnaround, but of course nobody's done new nuclear since, 1979 in 3 Mile Island. So I've done a few of those, but apart from that, I've done mainly power work, mainly disputes, construction cases, especially large complex cases, are often exposed to the dispute process, either litigation or arbitration. Over the course of those 43 years, I've traveled a lot around the country and outside the country. I did a count. I had an idle moment 10 years ago when I counted up that I'd practiced law concerning cases in more than half the states in the country: Puerto Rico, China, Central America, a wide variety of locations.
Do you have experience in litigation between owners and contractors under an engineering, procurement, and construction contract, which we refer to or have referred to in this proceeding as an EPC contract?
Yeah, I would say that these days, and actually for decades, the most common vehicle for an owner to engage a team to do power work is through engineering, procurement, and construction contracts. The purpose of that, of course, is that it sets up a turnkey arrangement. The owner has a single point of responsibility, a single person to look to. The old method, and the method still used in other areas of construction, would have the owner engage an engineer or an architect, and then the owner would go and hire a contractor. The owner might procure the material themselves, and then they might have 3 or many more points of responsibility if things went wrong. And of course, things go wrong, and those various people that the owner looks to then point the finger at one another. The engineer blames the contractor complains to the vendor complains to the architect, and around you go. And so the solution to that, it doesn't solve all problems, but the solution to that particular aspect, the multi-points of responsibility, was to develop EPC contracts. So I've been involved in recommending that method, of certainly litigated in both in courts and in arbitration contracts that use that method, and I'm very familiar with that arrangement, and I believe I'm familiar with most of the risks that are involved on both sides, both for owners and for the EPC contractor.
Can you provide the Commission with some examples of the types of large-scale construction matters that you've been involved with over the years?
Well, as I mentioned, I've done a wide variety of things. There was an expansion of the Atlanta airport. It was a $5 billion expansion program, and I represented the contractor who did the chief work in expanding the airport, adding a fifth runway to that airport. That involved being project counsel. Now, project counsel is somewhat different from the role of a litigator or the person handling a dispute in arbitration. In that case, I was meeting with the contractor frequently weekly, reviewing schedules, reviewing progress of work, sometimes writing letters, sometimes editing letters, of course advising on the contract and assisting the contractor to get that done, and the contractor got it done on time and on schedule. We had an owner who was willing to make a lot of adjustments in response to the letters that we wrote, and I think everybody regards that as a very successful project. In fact, the person who ran the airport, Ben DaCosta, said when he retired that he considered that his most successful effort while he was at the airport. Other projects that I've been involved with include Atlantic Station. If any of you get to Atlanta much, you may be aware that just off what we call the connector, there had been an old steel mill, Atlantic Steel, and that was torn down and a development was put in. But you can imagine there were a lot of hazardous materials that had to be dealt with, asbestos, in fact, even radioactive materials, because apparently they were used for alloys back during the war, the World War II. So in any case, that the mill was torn down, the site was remediated, and then a mixed-use development was put up. We're talking about hundreds of buildings. So I was involved in that project. I've been involved in multiple large power projects. I just finished a 20-month arbitration out of the country in where the dispute was in excess of $100 million, and that was actually a waste-to-energy project. And I was intimately involved with that. I served as project counsel for the last year of that project, and then during the 20-month arbitration, I was lead counsel in that dispute. I feel like I'm rambling on. I can tell you.
I just wanted you to give the commission a sense of your background and your expertise in the matters that you typically work on. I think you've done that. Do you typically represent the owners or the contractors in the types of disputes that you handle?
I would say the vast majority of my representation has been of the contractor.
Does your practice as a construction litigator involve some degree of knowledge of both construction and scheduling?
Well, it's inevitable. Frankly, one of the appeals of the practice of law is not the law itself, which you master after a relatively few number of years, but rather the subject matter in which you decide to specialize or focus your practice. Banking lawyers, no banking. IP lawyers, no inventions. Construction lawyers have to learn a great deal about engineering principles as well as all the tools that contractors use. So I'm very familiar with their accounting methods, with their scheduling methods, with the way things are generally put together. And that's kind of what keeps somebody going to practice for 43 years, learning new things with each case. There's always a little bit something different about how things are put together. Rarely is there something new about the law, frankly. It's always the assembly and the sequence of events that's interesting and that keeps me interested.
With respect to scheduling, are you familiar with a software program called Primavera?
I am.
What is Primavera? Well,
Primavera it's now owned by Oracle, which I think everybody knows. But it originally was a standalone company. CPM scheduling, this critical path method scheduling, had been around for a long time. I understand it was used during the Manhattan Project, some form of it. but the software came out in the early 80s, and it was DOS-based, and so there were very few people who were able to actually manipulate the software. In the early 90s, they migrated to a Windows platform, which made it much easier to understand. And in order to understand it, I actually had that software installed on my own computer so that I could understand, look under the hood, so to speak, of these schedules that I was getting from my contractor clients, understand how the schedules were put together, what kind of reports could be done, how to set up different calendars for different parts of the work, and those sorts of things. So I don't do a schedule, but I think that on a relatively simple project, I could put together a schedule. The real focus of my practice in connection with scheduling is evaluating the schedules of others, and that's both the project schedules and more frequently, in fact, in almost every dispute, the schedule analysis prepared by consultants hired by my client and as well as hired by the opposing client. So scheduling is an essential area to master if you're going to practice construction law, and I spend a great deal of time working on mastering it. In this arbitration that I just mentioned, I presented our scheduling expert and actually two experts and cross-examined extensively one of the preeminent schedulers in that country. So I feel as though I'm familiar with the principles, know where people go right and where people go wrong, and I've developed a sense of that.
I want to turn now our attention to your involvement in the project that brings us all together this morning. Were you engaged by SCE&G and Santee Cooper in connection with construction of the new nuclear units 2 and 3 at VC Summer?
I was first engaged in 2011 and was...
What were you engaged in 2011 to do?
Well, at that time, there were 4 claims by the contractor that were on the table. One was arose out of the NRC's, Nuclear Regulatory Commission's, requirement that the shield building withstand aircraft impact, and that required a redesign of the shield building. There was also a modification to the containment vessel. That was Claim 2. Claim 3 was a delay, which was really related to those two things, as well as the late issuance of the permit relative to when it was anticipated. And the 4th was a relatively small claim related to unanticipated rock that was encountered by the contractor. So those are the 4 claims that were on the table, and I met with representatives of the owner. I was engaged at that time, and then we worked towards analyzing those claims and attempting to move it towards resolution.
And were you able to assist the owners in resolving those claims that existed at that time?
We were, and I believe the Commission, if those of you who were on the Commission back in 2012 may recall that there was a $250 million increase to the contract amount, which resolved those claims. And we were quite pleased with what we accomplished in that negotiated settlement. I'm sure the Commission is aware of the Vogel project. The Vogel project had virtually the identical claims, except they didn't have the rock claim. So they had 3 of those 4 claims, and those claims then were litigated for years in federal court, and really weren't resolved until 2015. And so we were pleased that we avoided all the litigation costs and the distraction of having litigation during an ongoing project, but also we settled, that is, the owners, Santee Cooper and Scanis, settled for less than what the contractor was suing for on the Vogel case. So we were very pleased with the way that turned out.
After that amendment of the EPC contract in July of 2012 that you referenced, did that end your representation of the owners in connection with the project?
No, I continued to do work on a very irregular basis. Sometimes a month or more would go by and I wouldn't get a call, and then I would get a call and I'd have very intense involvement. I'd come up to Columbia I don't think I ever went to Monk's Quarter, but certainly the Santee Cooper came up to Columbia, and we often met at the SCANA campus and reviewed issues. I was involved in really being project counsel again. I had to learn the contract, understand the schedule, and then understand what was going on to cause the friction between the owner and the contractor. I often wrote letters that were then signed by representatives of the owner. Other times I would take draft letters and I would edit them to try to best position the owners in connection with whatever issue came up.
Did your representation extend into any other area of the project outside of advising the owners in commercial disputes with the consortium?
No, I can't think of anything that meets that description.
Did you ever provide legal advice to the owners regarding whether they should disclose any information about the nuclear project to the Public Service Commission or to the ORS?
No, I was certainly aware that that project was operating in a regulatory environment. That's not unusual. Most of in fact, nearly all of the power projects that I've been involved with operate in a regulatory environment, but that's not what I do. That's not my practice. That's not an area that I feel I have mastered or even that I fully understand. I often remind lawyers at our firm that the way you get into trouble is trying to practice in an area where you don't understand. I have some confidence in my abilities as a construction litigator and a construction counsel. I have no confidence in my ability to evaluate what the obligations are of a utility with respect to really anything else. That's not my interest, not my concern, not why I was hired, and not something that I feel qualified to do.
Did you ever represent the owners in litigation against the consortium?
No, we never had litigation. As I say, the Vogel plant did. I think through wise decisions on the part of the VC Summer owners, we avoided that litigation. And so we never really had litigation, but we were always exposed to the possibility.
That was going to be my next question. Were there times during your representation of the owners on this project that the prospect of litigation seemed likely?
There were, and it was an on and off thing. The owners were concerned about the contractor at several steps, and of course the contractor changed. We had Shaw at the beginning, and then CB&I, and then they took off as well. But we knew about the litigation involving the Vogel plant. I knew the lawyers for the contractors. One of them actually had been a partner at Smith, Curry & Hancock previously. I'd known him for 30 years. He's not shy about going to court. The CB&I group was represented by a firm in New Jersey. I mentioned there's another firm that does construction law with a national footprint. That other firm was representing CB&I. So we had the lawyer that I knew representing Westinghouse, another lawyer from a law firm that I knew very well representing CB&I. And I knew that they were aggressive people, and they were people who were not shy about going to court. And we had disputes that were hundreds of millions of dollars. So the possibility of litigation really was there almost continuously.
Mr. Winnick, are you aware that Bechtel Power Corporation was hired in 2015 to perform an assessment of the project?
Yes, in fact, I hired them.
To your knowledge, when was the suggestion first made to have Bechtel come in to do an assessment?
The first time that I learned of it was in May of 2015.
I want to direct your attention to the document that is behind tab 1 of your notebook, which is an email chain between you and Al Bynum, do you recognize the document behind tab number 1 in your notebook?
I do. This, I don't know. I don't actually know much about the evidence that's been presented to the commission, so I'm going to give some background here, and if it's redundant, I hope someone will raise their hand. The email in, string, there are 2 emails in the string. The email started...
Mr. Chairman, excuse me. Bob Guile for First Years here. I don't believe the witness is responding to any pending question.
Get that microphone, Mr. Giles, so we can hear you good.
I don't believe the witness is responding to any pending question. I believe he's simply volunteering information. Since this witness does not have pre-filed direct testimony, this party is at an extreme disadvantage, and hearing for the first time only today what a friendly party is seeking to elicit for the first time orally from the stand from this witness. We expected that this witness's testimony would be confined to a deposition, which now has been made available. I first saw it last night because it had been claimed to be confidential. It had been claimed to be confidential until then. So I'm simply trying to play catch-up here.
Okay, that's not you.
My point is...
Maybe if you hold that thing, Mr. Guile, and get it away from the others.
Let's try that, Mr. Chairman. My point really is because of the unusual approach to presenting this witness for the first time live without pre-file testimony, without simply restricting his testimony to the deposition, which all parties have at least had some access to. I had it last night, where the question and answers are given, and the format that we expected would be deposition would stand for testimony. Instead, Mr. Balzer has evolved this sort of last-minute approach to live testimony that obviously he's back. My point only is that if we're going to have any discipline at all, the witness should not simply be free to expound without being responsive to a question. In this case, he simply was offering a commentary. The only question was, do you recognize this document? He said he did. Then he wants to volunteer, unprompted, some kind of narrative about it. And I believe he should be held to being responsive to it.
Okay, we are going to sustain that. We do need to keep it at a question.
I apologize to the commission. Old habits die hard. I'm not used to being on this side of the question and answer divide.
This is what we call a direct examination, so I don't think there's anything strange or odd about eliciting testimony from a witness by asking him questions. So, Mr. Winnick, what is this email? Can you describe it for the commission?
Yes, it's an email that Al Bynum sent to me on May 20, 2015.
Who is Al Bynum?
Al Bynum, I don't know what his formal title was. I always understood that he was in-house project counsel, so he was an employee of SCANA, and his sole responsibility was in connection with Units 2 and 3 at VC Summer Plant. His formal title may well have been project counsel, but in any case, he was probably the individual with whom I had the most contact at SCANA, and he advised me that Santee Cooper wanted to hire Bechtel, and I was in favor of that. In fact, sometime in the previous year, I had recommended to the owner that they bring in, that I be permitted to bring in consultants to review the matter and inform me, because the end of 2014 was when the temperature of this possibility of litigation was turned up a bit. And I thought it was time for me to get a scheduling expert on board and an accounting expert on board in order to begin the analysis of the materials that were available to the owner. And so my initial response was, I'm in favor of that. Now you'll notice that Al Bynum says I'm curious to see if you have any problems with this. Again, I understood that I was brought in because of my experience in being a project counsel and in litigation. And Al, as in-house counsel, was doing his job of identifying issues.
One of the issues he identifies here, he says, are we just creating discoverable material? Did you have an understanding of what Mr. Bynum was referring to with that comment?
Yes, to a lawyer, that is a very clear reference to the phase of litigation during which you discover the materials that the other side has. And there are rules for that apply to court proceedings and often to arbitration proceedings as well. And so discoverable materials to me meant that Mr. Bynum had identified an issue. He had flagged an issue. He was concerned that we would be hiring somebody and that we would be creating discoverable materials, which has some risk to it.
Did the EPC contract have a forum selection clause for disputes that arise under the EPC agreement?
It did. It was a two-part dispute resolution procedure. One part called for arbitration of relatively small claims. Now, I say relatively small claims because we're talking about a multi-billion-dollar project. So we're talking about claims of I forget the number, but $20, $30 million, something of that size, that probably would never go to arbitration because the parties would resolve it. Any substantial dispute went to the United States District Court for the Southern District of New York. I wasn't involved in 2007. I don't know how they picked that forum, but that's what they selected. So the federal rules of evidence and the federal rules of civil procedure would apply to any future proceeding. I've been in that courthouse. I've handled matters there, and whenever the prospect of litigation arose, I imagined myself in front of a federal judge in Lower Manhattan in this courthouse, and I envisioned that these federal rules of civil procedure would be applying. Now, my response, I want to talk about a little bit more because the email that I received from Al Bynum had an attachment, and the attachment was several pages of a proposal that Bechtel had already submitted, and I was concerned about the language of what Bechtel was proposing to do. Bechtel, by the way, would not have been my first choice, but I certainly assumed that they were capable of fulfilling the function that I needed, giving me advice in anticipation of litigation. But they had written here that that for clarity, this team will not evaluate the ownership of past impacts or validity of pending or future claims. Well, that didn't do me any good.
Mr. Chairman, reading from a document that does not appear to parties to the knew my objection. The witness is simply expounding without question in a referring document. Parties, I would ask.
The document has been handed to Mr. Gold. It is in
one-page document.
It's in front of him.
To an attachment, like something that Bechtel said that has not been decided.
Let Mr. Butler talk about this.
So, Mr. Balser, has the document itself been provided?
Yes.
In what form? Is it
in discovery?
In discovery?
I know Mr. Gall didn't review any of the discovery materials because he objected to the format in which they were produced, but all these documents have been produced, every one of them.
Excuse, Mr. Chairman, we are at trial now. Evidence has to be presented in a disciplined fashion. Very least, evidence that's being referred to in the record has to be made available to parties now. Indeed, secret documents were not made available. This is one of those I don't know. All I can say is the witness now is not responding to a question. He's volunteering information. He's volunteering information referring to a document that is not available to the commission or the parties. I would ask either that his last answer be stricken or that he make that document available now so that we'll have an opportunity to effectively review it and cross-examine from it.
Mr. Balser?
The document that was attached to the email has been produced. It is in the record, or at least in the discovery record. We're happy to make it an addition to this document, which we can do at the break, and supplement the exhibit that we're referring to now.
That would be helpful. I think it would be helpful to provide it to the parties. At this point, Mr. Chairman, I'd recommend that we not strike the answer so far, but I would caution the attorney and the witness to just exchange questions and answers, as we have stated before.
So, Mr. Winnick, can you explain to the commission what your response to Mr. Bynum's question to you was and why you raised the issues that you raised?
Yes, if you go to the top of the page of the exhibit that's on the screen and pull out my response, you can see that I quote from page 1 of the Bechtel assessment proposal. So all of the relevant language that I was talking about is actually quoted in my email, and you can see the quote there, beginning with, "There will be focus on understanding the issues that have caused impacts to date," and so forth and so on. The last sentence was the one that troubled me. It said, "For clarity, this team will not evaluate the ownership of past impacts or validity of pending or future claims." And so I was concerned about that. The issue that Mr. Bynum had raised of discoverability under the federal rules is affected by whether someone is engaged in anticipation of litigation. So that was one concern. The other concern is, frankly, if this was being done in response to my suggestion that we bring on people, I needed to have a consultant who understood that he was providing information to support legal advice in anticipation of litigation. And this proposal was inconsistent with that, as I saw it.
So when you said we need to prevent Bechtel's product from being discoverable, tell the commission what you meant by that.
Well, during the discovery phase of any litigation, parties are obligated to provide certain categories of information. But there are certain categories of information that might be useful to the other side that you don't have to produce. For instance, matters that are privileged. I mean, the counsel has gathered by now that I served as counsel to SCANA and Santee Cooper, and I was their lawyer. And all of my conversations with them were privileged. Were it not for the waiver of that privilege, with some parameters that I'm not fully aware of, but there's a partial waiver of the privilege which enables me to testify and enables the discovery of my documents and so forth. Well, that applies equally to what would happen in any future litigation with the contractor. So I wanted to be certain that, first of all, that they were hired, that they understood that they were going to be supporting me. It was my suggestion that someone be brought in. I assumed at this time that they were acting on my suggestion. I later learned it was more complicated than that. But I assumed at this time that they were acting on my request that a consultant be hired to assist me in providing legal advice to the owner in anticipation of litigation. And if they're not going to look at past disputes or the validity of pending or future claims, they'd kind of disqualify themselves from really serving the immediate function, and also from providing information that might be withheld in the future in that litigation in the Southern District of New York.
So when you said we need to prevent Bechtel's product from being discoverable, were you did you mean discoverable by the Public Service Commission or the Office of Regulatory Staff?
No, again, that is not my practice. That's not what I understand Al to be asking me about. This is a issue that comes up routinely in construction litigation. We routinely have consultants, sometimes dozens. I mean, quite literally dozens.
So let's talk for a minute about your general practice in engaging experts. Is this something you had done before?
Again, I routinely engage experts. I use a form that I've developed over the years to hire experts. They are really essential. I can't think offhand of any arbitration or litigation involving construction where I didn't hire at least one and sometimes 4 or 5 or 6 different experts in order to assist me in understanding the case and ultimately provide testimony if appropriate.
Is there a typical approach that you take in retaining experts in your practice?
My typical approach, and frankly, I think the typical approach of most lawyers is that the lawyer engages the expert. And I have a sense of that that's the typical approach of others because I've of course, had people on the other side, and I've learned that the law firms retain the expert. But in any case, I know that is my practice. I retain the experts, and that's what we did here. Ultimately, we'll get to that.
Mr. Chairman, I asked that the document behind tab number 1 in your notebook, the email exchange between Mr. Bynum and Mr. Winnick be admitted as the next hearing.
The email will be entered as Exhibit 106.
Mr. Winnick, turn please, if you would, to tab 2 in your notebook before you. Ask Ms. Wilson to hand out the documents that are behind tab 2 to the other parties. Behind tab 2, there is an extensive email string among various people beginning June 1, 2015 and going through July 8, 2015. I want to direct your attention to the emails at the very top of this string, which are on the first page of this exhibit. So focusing first on Mr. Burns' email to Mr. Bynum, Mr. Crosby, and Mr. Archie that was then forwarded to you by Mr. Bynum. Do you recall seeing the email that Mr. Byrne sent to Mr. Bynum that Mr. Bynum then sent to you on July 8, 2015?
I do.
Mr. Chairman, I would ask that the document behind tab number 2 be admitted as the next hearing exhibit.
Be admitted as Exhibit 107.
So, directing your attention to Exhibit 107, Mr. Winnick, Mr. Burns' email indicates that a kickoff meeting had occurred between SCE&G, Santee Cooper, and Bechtel, which appears to have occurred in the first week of July. Do you see that?
I do.
And then can you read what Mr. Bynum says to you in the top email on Exhibit 107?
Yes. Mr. Bynum's email to me is dated July 8th, 2015, so about 6 weeks after the May email that we looked at a minute ago. And he said, any thoughts about how we set up this engagement, question mark, should it come through you, question mark.
You remember responding to this email?
I do.
If you turn to tab 3 in your notebook, we'll wait for Ms. Wilson to hand out these exhibits to the parties. Is the document behind tab 3 in your notebook your response to Mr. Bynum's July 8th, 2018 email?
It is. You'll see that Mr. Bynum's email was dated July 8, 2015 at 9:44 a.m. This document that's on the screen now is also dated July 8, 2015 at 9:46 a.m. So just a few minutes later. And I used the vehicle of his prior email from May to provide my response to remind Al that we'd already had some dialogue on this.
And would you tell the commission what your response to Mr. Bynum was?
Well, I explained to Al what I just explained to the commission a few moments ago, that my normal practice is to engage experts directly through a written agreement. I again mentioned the importance of keeping the Bechtel product privileged. And again, I object to the language in the proposal that I'd received with Al's May email, saying that Bechtel would not evaluate the ownership of past impacts or validity of pending or future claims. So again, I objected to that for the dual reasons that, one, they wouldn't be providing the product that I was seeking, and two, the product that they were providing would not be privileged under the federal rules of evidence, which would apply in the Southern District of New York.
Mr. Chairman, I move that the document behind tab 3 in the notebook be admitted as the next hearing exhibit.
It will be Exhibit 108.
Now, there is a last sentence there, Balzer.
All right, so
Email.
the last sentence says, if you wish, I will draft a personal service agreement using a form that we have used in the past combined with Bechtel's assessment proposal. What is the personal service agreement that you're referring to in this email that's Exhibit 108?
That's the type of agreement that I typically use and have used in the past, and it's obviously an evolving document where I change what needs to be changed, change the parties' names and the dispute and the rest of it, but it's a standard form that I use when I engage experts in connection with potential or existing disputes with adverse parties.
Turn your attention, if you would, Mr. Winnick, to the next document in your notebook, tab 4, which is, again, an email string. It picks up with the email that Mr. Byrne sent on July 8th, but then has an email from Mr. Mike Baxley dated July 13th, a response from you on July 14th, and then a response back to you from Mr. Baxley also on July 14th. Do you recognize the emails that are in the compilation behind tab number 4 of your notebook?
I do.
Mr. Chairman, I would move that the emails behind tab 4 of the notebook be entered into the record as the next hearing exhibit.
The emails behind tab 4 will be entered as Exhibit 109.
Thank you, Mr. Chairman. Have you seen Exhibit 109 before?
I have. I wrote part of it.
Okay. And these are emails exchanges between you and the owners regarding the Bechtel assessment?
They are.
I want to direct your attention to the email that you sent on July 14th, 2015 to Mr. Baxley, Mr. Byrne, Mr. Bynum, and Mr. Lindsay, with copies to Mr. Crosby and Mr. Pelcher. So can you provide some context? I think we probably need to start on the second page of Exhibit 108, in which Mr. Baxley sends an email that prompted your response. So can you just describe for the commission what's going on here?
Yes. So Mike Baxley is at this time is general counsel for Santee Cooper. He wrote me and others an email on July 13th, and what he said was that he was concerned about hiring Bechtel through legal counsel. That is, he was concerned about my following my normal practice of hiring Bechtel directly, and he also was concerned about including the phrase that Bechtel was, quote, was hired, quote, for the purpose of assisting counsel in giving legal advice to the owner. And his particular concern, as expressed in this email, was that he felt that we would not get full cooperation from the consortium. The consortium contractor at this time was Westinghouse and CB&I. And he thought that if Westinghouse believed and CB&I believed that we were retaining Bechtel to advise their legal counsel and in anticipation of litigation, that they would resist that. It turns out that was wrong, but we'll get to that in a minute. But I then wrote back to Mr. Baxley. Mr. Baxley is a former South Carolina judge. He's very familiar with these legal issues. So, but what I wanted the purpose of my email was to put some meat on the bones of this otherwise abstract issue concerning in anticipation of litigation. When I say meat on the bones, when you've been practicing a certain amount of time, almost every legal issue that you discuss with your client calls to mind some event or circumstance that you'd been involved with. And I find that giving those particulars enables a person to better understand what's at stake in connection with advice that I'm giving.
Okay, so let's take a look at this email, because I do think it's important for the commission to focus on what you were saying at the time. That's July of 2015. And you say, Mike, your email raises the question of whether we should obtain the consortium's cooperation with Bechtel's assessment effort, or we should protect Bechtel's work from forced disclosure in case of litigation, but I do not believe that is the dichotomy that we face. So I want to start first with the concept of protecting Bechtel's work from forced disclosure in case of litigation. What were you referring to there?
Well, again, I'm talking about forced disclosure in connection with an action filed in the Southern District of New York. That was always my focus. One of the first things that I look at in a construction contract when it's handed to me is the dispute resolution process. Is it arbitration? Is it litigation? Is there a dispute review board? Is there some other alternative method for deciding disputes? And then what's the forum? And the choice of law. And all of those things are immediately relevant, and I want to establish the proper lens through which to read the contract. So from the beginning, the first day that I received the construction contract, I was aware of the venue provision concerning the Southern District of New York. And what I'm referring to in item 2 is protecting their work from forced disclosure in case of litigation. Now, I didn't have, of course, anything from Bechtel at this time, but I'd been around the block before on this, and the email describes that trip around the block before.
So let's talk about that. So if we look at the, as you call it, the trip around the block, on the second page of Exhibit 108 at the top, you refer to litigation in the USDC, which is U.S. District Court for the Western District of Pennsylvania, concerning a coal-fired power plant. Do you see that reference?
I do.
So without just rereading the language that is in the email, can you just describe to the commission the circumstance that you were describing? And we're now behind tab 4, Exhibit 108.
Exhibit
109. I apologize. My mistake. We're on 109, so sorry for the confusion. Tab 4, 109, top of the second page. There is a description of a prior litigation that you were involved with. Can you tell the commission about that matter?
I can. As it states there, it concerned a coal-fired power plant. Coal is plentiful in Pennsylvania. There are a lot of enormous power plants that use coal as a fuel. This was one of them. The opposing party was ABB, a multinational energy provider that has since been absorbed by another company. But We had a dispute with them. I represented the contractor. ABB had hired the contractor to do work on that plant. Claims arose during the course of the project. Claims asserted by my client, the contractor, against ABB. And ABB brought in a consultant. And it was clear from what I could glean that the consultant was hired because ABB wanted to resolve disputes in the normal course of business and wanted some guidance from the consultant. That is, the consultant was not hired, in my judgment, in anticipation of litigation, but rather to provide advice in the normal course of business. And that's the dichotomy, the legal dichotomy, as I understand it, in applying the rule for forcing disclosure. And we were able to force disclosure. We persuaded the federal judge in Pittsburgh that the consultant was not hired in anticipation of litigation, but to give advice in the normal course of business. Now, the consultant, in giving his opinion, didn't have the benefit of any discovery because there was no litigation that had been filed yet. In fact, I hadn't even been retained for this dispute at the time he offered his opinions in written reports, actually a series of reports on these claims. So it was based upon incomplete information, but it was something that ABB was looking to the consultant to do because they didn't feel they had the in-house capability to evaluate the claims. But we were able to force disclosure. And I'll tell you, in litigation, when you have a report that's favorable to your client, it is the shiny object. And I knew that it would dominate any future trial if we had to get to that point. And frankly, the lawyer on the other side, once we eventually filed suit, he recognized that issue as well, that this was the shiny object, because the consultant would then be viewed as being speaking for the owner. And so anything the consultant said that was favorable to my client would be viewed as an admission by ABB that my client's claims had merit. So effectively, well, you can see that I use the word that the consultant decided. I put it in the quotes because obviously the consultant wasn't the judge, or let alone the jury. But they effectively decided it because they wrote a report that was favorable to my client. We got a copy of the report, and the reality of litigation is that report would have led to a successful resolution. So
you say, so you went on to say in your email, the same could happen here with the Bechtel report. We should give careful thought to whether we want to put Bechtel in the position of possibly deciding any eventual dispute based on a 7-week review. Do you see that?
Yes. That's,
what did you mean by that?
Well, that the situation would be analogous. That just as ABB hired a consultant and the consultant said things without enough time or enough information, but said things that were favorable to the other side, that Bechtel might do the same. And I'll tell you, 7 weeks to get your arms around a project like this is inadequate. It takes months, sometimes years, of discovery before the two sides in a construction dispute
Mr. Chairman,
are comfortable.
I've got an objection now to Mr. Winnick's offering opinion testimony. We've known this was coming. We don't believe he is qualified to offer opinion testimony about the engineering issues that are at issue in this case. It's perfectly appropriate for him to talk about his involvement, his role, the things he's been talking about. But under Rule 702, Mr. Winnick we don't believe Mr. Winnick is qualified to testify to opinions about the adequacy of what Bechtel did. He offered those opinions at his deposition, so we've known that this was coming. There was an effort made at the beginning of the direct examination to lay the grounds for qualifying him. We don't believe he is qualified. He's a construction lawyer, extremely experienced. That doesn't make him an engineer. And so we don't think he should be offering opinion testimony about the engineering issues, the adequacy of the time Bechtel had, how they did their work on what level of schedule should have been done, those sorts of issues we have an objection to. And since the testimony is sort of extending on and not necessarily responsive to questions, I thought it best to get up and put the objection on the record now.
May I respond, please?
Yes.
The issue that Mr. Winnick is eminently qualified to offer an opinion on is the reliability of the Bechtel assessment based on his 40-plus years of experience retaining, examining, and cross-examining experts in the construction field. So he is not offering opinions on constructability, engineering, or anything of the like, but he certainly is qualified to share with the Commission his views of the reliability of this report based on the expert that he retained in anticipation of litigation as to whether and to what extent he believed that that report had any merit or reliability.
Mr.
May I respond to that, Mr. Chairman? And I'm happy to be joined by my colleagues. I did not identify myself. It's Frank Ellerby for the cooperatives. I've got a partner that's been defending medical malpractice cases for 30 years. I would not let him operate on me. He would not be allowed to testify in the courts in this state on the standard of care for physicians. And that's what we're doing here. We've got a witness who was identified on a may call list. We were never told that he was going to be an expert witness to offer these opinions. He was a may call witness. He had factual information. But to convert him on the fly into an expert witness to talk about engineering issues and to criticize the conclusions of the Bechtel report, because that's where they're headed. And that's inappropriate. That's beyond the scope of his expertise, and we object.
Mr. Chairman, Bob Guile, Friends of the Earth Sierra Club, we join in that objection and believe it's doubly improper because the rules of the game that we established here for non-pre-file witnesses were that in limited circumstances, the depositions of those witnesses could stand for pre-filed testimony. And indeed, as I explained earlier, Mr. Winnick's deposition was made available to me last night in a non-confidential form. But that does not provide license for free-ranging, spontaneous cross-examination or friendly direct examination, I should say, on this subject. It's a surprise. It's unfair. We try this case based on pre-filed testimony, some of which has been available for months. It allows us to prepare, have appropriate rebuttal and surrebuttal, prepare cross-examination. This unusual approach not only exceeds the witness's qualifications, but also provides unfair surprise to the other parties, and I believe to the Commission. You're not going to get a fair record in this case. So we would object to him being offered for opinion evidence on this subject and join the other.
Mr. Chairman, may I respond, please? Mr. Ellerby said they were fully aware that this is what was going to be done. Mr. Guile certainly had the opportunity to appear and attend Mr. Winnick's deposition. He chose not to, so his claim of surprise as to what Mr. Winnick would or wouldn't say, or his accessibility of the deposition transcript is a problem of his own making. He certainly could have attended. It was noticed in this matter. The ORS has presented testimony that the purpose of Mr. Winnick being hired was to conceal the Bechtel report. That is the theme that the ORS has developed in this case. This witness is the one who is intimately familiar with the retention of Bechtel and the reasons why the Bechtel report was viewed as not being reliable. So he's got to be able to testify about this.
Mr. Chairman, in order to make the record complete, Matthew Richardson for ORS, we also object to the admissibility of this lawyer testifying or trying to testify as a construction expert in any way, shape, or form. He's not. Mr. SCNG actually has a construction expert that is a pre-filed testimony witness, Mr. Petitioner. He'll be here on Monday. He certainly is capable of addressing these issues. Mr. Winnick is not, but it goes a little bit farther than that for us. You remember in the first day of the hearing, we had some preliminary matters, and one of the ones was objecting to kind of legal testimony written by lawyers and provided to this commission as if it were, evidence for the case. And this, we said that we were withdrawing our objection to the admissibility because we think this also goes to the credibility of the witnesses, and we'll make that argument. And that's what Mr. Balzer just addressed. We'll address the credibility issues here with Mr. Winnick's attempt at challenging Bechtel. But we do want to make this admissibility objection as well, given the nature of his testimony here today and based on Mr. Guile and Mr. Ellerby's objections. Thank you.
Okay, we're going to sustain the objections and ask Mr. Winnick just stay focused in on the question. Don't expand.
All right, Mr. Winnick,
Yeah.
we've seen from the emails that it was your preference that you hire Bechtel in anticipation of litigation. Did your clients have the same views as far as the purpose of Bechtel's assessment and how Bechtel would be engaged?
Yes.
I want to look back at the email that Mr. Baxley sent that prompted your response, in which he expressed some concern over engaging Bechtel in anticipation of litigation, and we just saw that your response to that. Ultimately, how was Bechtel engaged?
I used the standard form that I've used in the past to engage experts, and I customized it to this issue.
At the time that you engaged Bechtel in 2015, did you anticipate that litigation with the consortium was imminent?
Yes.
What was the litigation that you anticipated at that time?
At that time, CB&I was very directly threatening to bring litigation against the owner and quite possibly against Westinghouse as well. And those threats were made to executives of the owner, and they were passed down to me, and I was asked to evaluate our position on a variety of claims. The claims in place at the time, I'm perfectly happy to describe.
What were the claims?
So the claims, one of the several claims, and there were more than a dozen that totaled several $100 million. But one of the claims related to payments under the contract. The Commission may or may not be aware of the regime for making payments under the original EPC contract. There were 4 different ways in which to make payments, and 2 of them involved making payments of dollar amounts certain on dates certain. But the contractor was projecting that he would be late, and if the payments were made in accordance with those schedules, then payment in full would be made before the contractor was finished. So one of the issues was how that payment provision should be adapted in a case where the owner knew that the contractor was going to be late and the contractor knew that he was going to be late. There were other claims for extra work. As I say, there were about a dozen claims that I would evaluate at having about a value of about $250 million.
Right. Turn with me, if you would, to tab 5 of the notebook. There's a document there that is titled Professional Services Agreement. You recognize this document?
I do.
What is it?
This is the document that I drafted initially, and then there was some negotiation with Bechtel's in-house counsel, and this is the version that was ultimately signed. It's based upon the type of agreement, the form agreement that I've used to engage experts in the past, and of course it's adapted to the Bechtel engagement and the VC Summer project.
Turn with me, if you would, to attachment A of the professional services agreement. So the agreement itself is 5 pages, and then there's an attachment. Attachment A, if you turn to page 1 of that, I'd like to focus your attention on the first paragraph. Can you read what the first paragraph of attachment A says?
I can. The objective of Bechtel's assessment is to assist SCH, that's Smith, Curry, and Hancock, and owners in better understanding the current status and potential challenges of the project in anticipation of litigation, and also to help ensure the project is on the most cost-effective trajectory to completion.
Did Santee Cooper agree to your engagement of Bechtel under this agreement?
It did, and in fact, that similar language is contained in paragraph 3 on page 1 of the agreement.
So, I'm sorry, to direct our attention to that.
Page 1, paragraph 3.
And what does that say?
That says that all communications related to the services between Bechtel and any attorney, agent, or employee of Bechtel on the one hand, and any attorney, agent, or employee of SCH or owner on the other hand, shall be regarded as confidential and made solely for the purpose of assisting SCH in giving legal advice to the owner.
Did SCE&G agree to your engagement of Bechtel under this agreement?
It did.
What was it that you asked Bechtel to do? What was the scope of their assessment in your view?
I assumed that Bechtel was experienced in doing the type of review that I was engaging them to do through my law firm.
What was that review?
And that review was to identify issues on the project, determine what the causes of the problems were and what problems we might expect in the future. I expected them to, for example, look under the hood of the Westinghouse CB&I schedule. There are a lot of things that schedulers can do that are not apparent, even on a relatively simple schedule, that can cloak issues. This was not a simple schedule. This was a very complex schedule. And so I wanted to understand if there was anything in the Westinghouse schedule, Westinghouse CB&I schedule, that was cloaking issues that had not been revealed to the owner. And I also wanted to understand what the causes of of any problems were, and also I wanted to understand the effectiveness of the mitigation measures that the contractor had put in place. And all of that is stated in this agreement.
Was Bechtel asked to run a new schedule and projection of completion dates for the units?
No.
Turn with me, if you would, to page 4 of Exhibit A, or Attachment A, of the Professional Services Agreement, specifically Section E. How long was the assessment scheduled to last?
Well, as it states in the paragraph to which you directed me, it was estimated to take approximately 7 weeks.
And if you look at Section F, how many Bechtel personnel were staffed on the assessment?
The agreement identifies 8 people. There were ultimately a dozen, I believe.
How was Bechtel going to be compensated for its assessment?
There was a lump sum payment, which would be paid out in separate smaller amounts, totaling $1 million.
Did your law firm, Smith, Curry, and Hancock, actually make the payments to Bechtel for the assessment?
No, we didn't actually cut the check.
Is that uncommon in a case where you've engaged an expert to have the client make the payments directly to the expert?
No, it's not uncommon. The agreement was between my law firm and Bechtel. It was clear that this was an expense to my law firm, and rather than run the dollars through our books, the owner, in this case, as my clients do in many cases, paid the Bechtel invoice directly. Invoices came to me, and then I forwarded them to the client, and the client paid them.
Do you have any opinion about the compensation structure of a lump sum payment for the assessment?
Yes.
What was your view?
My view was that was not the best way to manage a consultant. My normal approach is to identify the billing rate of the individuals who would be retained and involved with the engagement, and in some cases there might be a not to exceed amount identified. Identifying a lump sum sets constraints on the work that I would not normally want to have and don't have.
Did the consortium participate in Bechtel's assessment?
They did.
What was, do you recall an agreement being before I go to that, Mr. Chairman, I had asked that the professional services agreement behind tab 5 in the notebook be marked as the next hearing exhibit.
It will be marked as Exhibit 110.
And entered into the record.
And entered into the record as 110.
Thank you. Do you recall an agreement between the owners and the consortium regarding the Bechtel assessment?
I do.
If you turn to tab 6, can you identify that document for the commission?
Yes, the document behind tab 6 is an agreement regarding the owner's project assessment dated August 7, 2015. And you can see that it has signature blocks for SC DN, both for itself and as agent for Santee Cooper, and as well as signature blocks for Westinghouse Electric and CB&I, Stone & Webster, and those are all signed.
Were you involved in negotiating or drafting this agreement?
I was. I wasn't. I don't want to mislead anybody. I didn't draft it to the same extent that I drafted the personal service agreement by which we retained Bechtel. But I was involved in the drafting. The drafts were sent to me, and comments were solicited and comments were provided.
Explain to the commission, if you would, what the purpose of this agreement between the owners and the consortium was.
Purpose related to disclosure of information that Bechtel learned through its review. There was already a non-disclosure agreement that virtually everybody had to sign in connection with the project if they got involved. That was an exhibit to the original EPC contract. But in it, and Bechtel did sign one of those. I think it's Exhibit O to the contract. But in addition to that, the consortium wanted a one-off provision instead of the standard exhibit to the contract concerning non-disclosure. And so that document was circulated and eventually executed, satisfying the contractor, to all appearances, that information gained by Bechtel would be kept privileged and confidential.
Okay, and on that point, let's look at paragraph 2 of this agreement, which says, owner, by and through its attorneys, plan to retain Bechtel to perform an assessment of the project. Bechtel shall, only through certain of its employees who are so designated and agreed upon by owner, perform its assessment at the direction of owner's counsel, and the assessment process and any documents issued in conjunction therewith shall constitute privileged and non-discoverable attorney-directed work product. The purpose of the assessment is to assist in owner's counsel's provision of legal advice to the owner relating to the project. Owner and contractor agree that the assessment and all papers, documents, and communications generated by owner's attorneys, and Bechtel as a result of and in connection with arising out of the assessment, including the assessment report itself, are intended to be and shall be legally privileged as attorney-directed work product and attorney-client privilege communications. Why did you think it was necessary to let the consortium know up front that this was going to be that the work Bechtel was going to do would be protected under the attorney-client privilege and attorney work product doctrine?
Well, we knew that the contractor had concerns about the publishing of the of any statements by Bechtel. They also were concerned about Bechtel's internal use of that information gained because, frankly, they were competitors at the time, specifically competitors for the AP 1000 Westinghouse nuclear units. And so they wanted to make certain that there was limited circulation, limited use, and specified use. And the paragraph goes on to reference really quite specifically what the understanding was. You can see that it says that the owner and contractor agree that Bechtel is a non-testifying expert and provided by the federal rules of civil procedure. So go to page 2 and pull out the top incomplete paragraph. You can see there's a citation to the federal rules of civil procedure. I alerted to those earlier this morning. That specifically relates to consultants hired in anticipation of litigation, and that's what they were. And so the Bechtel agreed to that in their PSA. Certainly the owner agreed to that in this document and in approving the personal service agreement, and the contractor understood that. So from my perspective, I didn't know about all communications with Bechtel, but from my perspective, on a legal basis, I understood that it was crystal clear to all parties the terms of engagement.
Were you aware of any issues with the consortium providing Bechtel access to documents it needed for the assessment?
There were issues that arose, and the complaints filtered back to me. There were certain documents that the consortium ultimately decided not to provide. There were certain documents that were only provided in a reading room with no right to copy, that you could only go into that room and read them. Certain documents were provided even in that context, in the reading room, that had been redacted. So those complaints came back to us. And there was information related to status of work that Westinghouse specifically refused to provide. And I apologize for repeatedly referring to Westinghouse because ultimately it was just Westinghouse. But what I mean is the contractor at this point. This was before the exit of CB&I.
Did the issue with Bechtel's access to documents color your view of the eventual assessment that Bechtel produced?
It did. It colored my view, and part of the reason it colored my view was because Bechtel said it restricted them. They identified quite clearly, both orally and writing, the limitations of what they were able to do because of the limited access to information.
When did Bechtel complete its approximately 7-week review?
It would have. My recollection is that it was in late October, and I have that time period in my mind because I know that they made an oral presentation on October 22nd. That's a date that's stuck with me.
Before we get to that, Mr. Chairman, I'd like to move for admission into the record as the next hearing exhibit the agreement regarding owner's project assessment that is behind tab 6 of the notebook.
Okay, the agreement behind tab 6 will be entered into the record as exhibit 111. And before we go further, we're going to take about 10 minutes break.
Thank you, Mr. Chairman.